Can you unmute?
Oh.
I muted it.
Oh, okay.
We're on the record, this is 2023-31866 CICI.
Can you unmute, Your Honor?
You should be able to hear me through the court. Can everyone hear me?
Yes, Your Honor.
So let's try it again. This is 2023-31866.
Can you unmute, please?
Ma'am, everyone can hear me? Who's saying they cannot hear me? Madam Court Reporter, you can't hear me? Everyone else can hear me, so I'm not sure. Awesome. Teresa, can you send her a message and let her know that the audio is working from her? Oh. I'm sorry? I got it.
No, right? I have not heard the judge yet.
Teresa, can you
I don't know why.
email her message her and let her know that.
Oh, no, I hear you. Okay.
Okay, very good. All right, we're here on 2023-31866 CICI and 2023-30354 CICI. The caption of the case is Schoenbrod on behalf of himself and his minor child LS, and Jessica Long on behalf of herself and her minor child LS. And it on the 30354, that's versus the State Attorney's Office, 7th Judicial Circuit, Florida Department of Law Enforcement, and City of Daytona Beach Shores, and the Sheriff's Office. 2023-31866 is same petitioners versus the State Attorney's Office. We'll go ahead and do appearances, starting with counsel for the petitioner on both cases.
Michael Lambert on behalf of both petitioners, Ms. Long and Mr. Schoenbrod.
And then if you could kindly, the respondents can kindly first put their appearances on.
This is David Smith. I'm representing the State Attorney's Office at the 7th Judicial Circuit.
Good morning.
Good morning, Your Honor. This is Paul Waters with the Bose Law Firm. We represent the City of Daytona Beach Shores.
Good morning.
Good morning.
Good morning, Your Honor. Janine Robinson on behalf of the Florida Department of Law Enforcement.
Good morning.
This is Antonio Grimes, General Counsel for the Clerk of the Court. I'm not named as a defendant, but we have been involved in the case, so I'll just make an appearance just in case.
Thank you. Good morning.
Good morning, Your Honor. My name is Lynn Lambert. I'm a performance public associate. I am here on behalf of the Florida Center for Government Accountability, the Accountability Manager Law.
Good morning, Ms. Norbert. Your audio is a little bit weaker than the others, just so you're aware. We're here on the motions for confidentiality, and then the motion for consolidation. I'm going to hear the motion for confidentiality filed in 31866. Mr. Lambert, it may tie in and there may be some overlap. But we'll start with that one, which was the most recently filed motion along with the motion to consolidate in that case, whenever you're ready, sir.
Judge, one of my issues is with regard to the media, that I do intend to present some testimony. I'm not comfortable with them being here or going to determine that this remains confidential, if they not reported.
This was not noticed for an evidentiary hearing, so if there's testimony that you're going to put on, I'm not sure if we're going to get into the substantive issues. So your concern, while it's noted, I think I'm comfortable going forward. If I feel that we need to re-raise the issue, or we get into things that may cause pause, we'll cross that bridge when we get to it.
And additionally, Judge, I don't know if the court had the opportunity to look at all the attachments to the pleadings that deal with regard to issues of confidentiality that were attached to the motion for the temporary injunction.
I have.
And Judge, that's how this began, was a motion for temporary injunction to enjoin the state attorney's office, the sheriff's office, Florida Department of Law Enforcement, and the Daytona Beach Shores Police Department from releasing information about a particular investigation that was generated by Division of Children and Families. And the court is well aware that DCF records or anything they generate are confidential by statute and not to be released. The court entered a temporary injunction prohibiting the release of any of that information back in March. In early April, I requested a hearing on the confidentiality of these, to continue the confidentiality of these. I repeated the motion, I think within late June or early July. The issues that we're dealing with obviously are children and the impact of this on children. The impact on the petitioners themselves, that in order to prevent any injury to them, whether physical, mental, or emotional, as a result of the release of any of this information. The denial of due process rights or a fair proceeding, because as we've seen already, even though the court entered an order temporarily enjoining these agencies, the sheriff's office has released the DCF video, in this case, to the news media. And this is after a second order was provided to them on July 13th and July 17th.
I'm going to just stop you there, Mr. Lambert, just because I am concerned that Mr. McGlashan is not on from the sheriff's office. So I was hoping that by the time we kind of got started that he would appear. He's not done so. I'm not sure if there is an update on that. So to the extent that we're going to go down that road, I'd pause in an abundance of caution because he's not here. We were alerted as to the reason why, so we're just waiting on him to.
Okay.
To the extent that you can continue, if that's. So that's why I wanted to start with the latter case, which is strictly against the state attorney's office on the petition for mandamus. So we could resume from that. That was why I alerted you. That was where I wanted to start.
Okay.
Thank you.
I didn't hear that. With regard to that, Judge, that dealt with the effort to obtain certificates of eligibility to get the records civil funds. There's a requirement pre-ministerial on behalf of the state attorney's office to fill out a portion of that form. It was sent to that office and nothing was done. Communications back and forth, some of which it's above my pay grade. I don't handle that kind of stuff. What you're doing is improper, things of that nature. So finally, it just got frustrating, nothing was being done, so I did the petition for the mandamus. The court issued a rule to show cause to the state attorney's office. State attorney's office said they never received it. I think I have proof that it was sent to them by the court through the P service. But then when the court issued this rule to show cause, or requirement that they file something within 30 days to show cause by the writ should not be entered. About 8 days later, they responded and filled out a portion of the form, and they returned it to our office. It was sent to FDLE. FDLE sent it back, said that they had failed to fill out other parts of it, such as signature lines and things of that nature. They put little arrows, the yellow arrows, and the assigned documents on it. We returned it to the state attorney's office. I've never heard a word about it since.
So in terms of the motion for confidentiality as it relates to that case, can you specifically address that?
Well, what it is, because of the allegations that are contained in there, about the investigation, I don't know that there's, I don't think about it, I don't know that there's anything in it that would impact either the petitioners or their children. But it was consolidated, or attempted to be consolidated, just to show the continuity of what was going on, so that there not be a separate proceeding.
And that's the basis for your request to consolidate that case with the prior case. Can you speak to Mr. Smith's response? And I'm sure he'll, I can give you an opportunity to reply to his argument, but he did file a written response, essentially arguing that whatever they needed to provide to FDLE, they had done so. That's very, very overbroad, and he'll respond. But can you at least address that, and then I'll give him an opportunity to respond to your position on that.
And what happens is, once the state attorney's office fulfills its obligation, it sends it back to us, and we send it on to FDLE. After that, I've not seen it after returning it to the state attorney's office and saying we feel to complete these portions of it. And again, that was part of what was requested in the court issuing the writ, and that there was no response.
Well, I didn't issue the writ. I issued an order for that. I did not issue a petition for writ of mandamus. I issued an order for the state to respond to it. So I want the record to be clear that that was what the order. I've not issued any writ to them at this juncture.
No, I agree. I sent the court a copy of the proposed writ, and that there was no response after the 30 days. But again, I received nothing from the state attorney's office about a completed form. Additionally, the state attorney's office was saying that the procedure is incorrect. It should be one to expunge. It should be concealed because there really was nothing that was filed or done, etc. That's quite commonplace. So that complaints are filed with the state attorney's office, and nothing makes it to the clerk's office. However, a decision is made. In this case, I believe I attached to either that pleading or the initial pleading, the response to the state attorney's office, which I reviewed as an announcement of the more information, even though it was done under the title of a memorandum. It was based upon a criminal complaint that had been filed with the state attorney's office against each of the petitioners.
Mr. Smith, did you want to respond to this? We're just trying to tailor it to the mandamus issues and talk to me about, I mean, again, so it's your position, Mr. Lambert, just so I stay on script here, because we're here on the motion for confidentiality and consolidation. Your position is you're going to rely on your motion as to why that should be confidential, that particular case.
Yes,
All right. Mr. Smith?
Yes, Your Honor.
Good morning.
Good morning. When it comes to this, as I stated in the response that I filed just last week, the state was somewhat oblivious to most of these pleadings and the court's orders. We only discovered by happenstance, as I stated in my response, when we were in the midst of answering a public records request, that there was a civil case involving the same individuals that had been sealed. And we then started looking, couldn't really get any copies of anything, but were finally told, yeah, it's sealed by confidentiality under the court records, not the rest of the case.
So, Mr. Smith, in terms of the motion for confidentiality in this case, which is on the petition for mandamus, can you just respond specifically to that in terms of, I mean, the tenor of your response to me was that it was now moved, that you had done what you needed to do. So in terms of, we're kind of getting into the merits of the petition, but I just wanted to address it in terms of confidentiality and where you are. So can you kind of talk to me a little bit about that? If I misread your reply, certainly tell me no, but it sounded to me that you felt your office had done what they needed to do.
That's correct, Your Honor. To address that directly, the form that FDLE has in their regulations is called the sealing or expungement form. Basically, it's a certificate of eligibility. It's a 2-page document. The first of which is for the sealing. The second page applies to expunction and is applicable only to expunction. And that is the only page the state attorney has any involvement with. The state attorney has no signature, nor is it required by statute to sign for sealing, which is the first page. Mr. Lambert and his clients filed for an expunction under the second page, which is fine. And we did sign it. We did not sign it on the basis of his filing a motion or seeking a writ of mandamus or the court's own order for us to respond. In fact, we had signed it the day your order came out. We did not seek your order. We had signed it.
We checked on that to make sure we served it, and our clerk site shows that it was opened on the 26th twice, so of May, and then viewed on June 26th. So we were pretty, we wanted to make sure that that order had gotten to your office, so it was open. But I just want, so your position is what was signed by Ms. Kane on the 24th was sufficient to, for purposes of the efforts the petitioners were making to get their records addressed by FDLE.
That's correct. It's not going to be sufficient as far as them expunging anything because there's nothing to expunge. We can't fill in a charge box because there was no charge. We can't fill in the statute or the case number or the action because there was never a criminal request for a warrant to be issued. We never received a 707 from anyone. There were investigative summaries, there were affidavits, there were things of those natures, but there was never a request for a warrant and there was never an arrest. There was never a charge filed by the state. And therefore, there was nothing in what is called the criminal history record on the system to expunge. Those other records exist, which could be sealed. In fact, there's an argument to be made that they should automatically be sealed since there was never a charge or anything. But I leave that all to the court and the parties that are involved in that sort of thing. Our position is we've done everything there is for us to do in the form, and we have no position as to the sealing or expunction or confidentiality. We'll do whatever the court tells us to do.
Thank you, Mr. Smith. Mr. Lambert, if you wish to respond to that.
Yes, Judge. The only thing I would request then is what it was that they filled out and sent somewhere. I'll be glad to receive it.
Well, Mr. Smith, are you alluding to the May 24th documents that was there something additionally that were signed by one of the prosecutors in your office, Ms. Kane, or is there something additional that Mr. Lambert is speaking he has not seen?
No, Your Honor, the only documents are the May 24th one. I have seen the original of that here. Mr. Lambert sent it back to us after FDLE sent it back and said that the boxes need to be filled in. We then explained there's nothing to fill in the boxes. You need to seal, not expunge, and we don't sign the seal anyway. So we still have that original document here someplace that Mr. Lambert sent back to us.
So that means it hasn't gone anywhere.
I'm sorry, go ahead, sir.
We had sent it back to you originally in May. You sent it to FDLE. They sent it back to you. Then you sent it back to us, and now here we are here.
So it's still at the state attorney's office. So the issue would be whether or not, based upon an another reason, Judge, why the petition for writ of mandamus should be confidential is that it contains all the same information as the petition for the injunction.
Ms. Robinson, I know that you're not a party to this mandamus discussion on the FDLE documents. Is there anything that you wish to add as sort of a friend of the court on that matter? Just since we're talking about what your documentation requires, so if there's anything you wish to add. And if you don't, that's fine.
No, Your Honor, actually, I'm just here for the confidentiality motion, what our program area for seal and expunge does. I know, Mr. Smith has been working, so nothing to say on the seal and expunge.
I understood you're here, so I wanted to give you an opportunity if you wish to. You're welcome. All right, anything, so, Mr. Lambert, are you disagreeing, I mean, in terms of substance of what their position is, they've done everything that they need to do under the FDLE requirements. So I'm sort of struggling with what's left on this petition for mandamus. I mean, it sounds that you all are at an impasse, and you're asking me to compel them to do something that they believe they've already done.
Well, if they've done it, could they send it to me? Because Mr. Smith was saying they still have it.
Mr. Smith, last word on this. He's saying, Mr. Lambert's saying that you still have it. You're saying whatever you have is what was, I mean, it seems it's been back and forth.
Right, we sent it to him originally back on May 24th. My impression is he sent it into FDLE, they sent it back to him saying the boxes need to be filled in. There's nothing for us to fill into the boxes other than putting not applicable, which we will be glad to do, and send it back to Mr. Lambert if that's what he would like. We can leave it to the court and Mr. Lambert is what they would like us to do with that, but we can't make up numbers and put them in because they don't exist.
If he puts not applicable in the boxes and gets it back to us, that's where we are.
That'll work, Judge. The only problem is I view the memorandum done by the state as no information based upon a criminal complaint that's filed by FDLE.
Good morning, Mr. McGlashan. Can you hear us okay?
I can hear you, Judge. Thank you.
You're welcome. If you could go ahead and put your appearance on the record for us, sir.
Peter McGlashan on behalf of the Volusia Sheriff's Office.
So, Mr. McGlashan, just to kind of give you a roadmap, we have two cases on the docket on the motion for confidentiality. I heard the latter case, which was exclusively against petitioners versus the state attorney's office on petition for mandamus. And I wanted to hear that case first anyway, but also to not hear the first case, which you're one of the respondents until you could get on. So I just wanted you to be aware of what I've heard thus far.
All right, thank you, Your Honor.
You're welcome. All right, with that, I'm really, Mr. Lambert, why I'm pushing on this petition for mandamus is it sounds like it's moot at this juncture. So that's why I was trying to kind of get that one out of the way in terms of the exchange of information between you and the state attorney's office. It sounds like Mr. Smith's amenable, and we'll go ahead and fill in whatever he believes is not applicable and return that to you. So to me, the petition for mandamus is moot at this juncture.
Judge, my only response to that would be is that my position was that a criminal complaint was filed. They did do a no information by way of the memorandum. I actually sent them a letter, I think, which I attached to my request for the petition for this mandamus, showing the way I suggested that they fill it out and then send it back to me so I can send it to FDLE. But if they're not going to do that, I mean, mandamus would be the only way to require that, but I'll send it on as it is.
Let's move on to, I'm going to just kind of leave that there for now, and we'll move on to the motion for confidentiality in the other case. If you want to continue your argument on that, Mr. Lambert.
Yes, ma'am. And again, it involves DCF information, a video recording that was done by the sheriff's office, who was not there in investigative capacity, but rather just as support to DCF. The officer did have his body camera on, and they recorded, KBC recorded Officer Schoenbrod in his uniform, He recorded the exterior of their home, he recorded the interior of their home, he recorded the children's names and the children's ages.
So under chapter 39, I don't think the sheriff's office would disagree that there's certain, and certainly certain information, privacy information about law enforcement officers under chapter 119 would be applicable, even with a motion for confidentiality or not. Those are statutory requirements.
Right.
Okay. All right, so understanding that portion of it, let's go.
Okay, and just so the court knows that that's been breached by the sheriff's office. The other is to prevent the serious and imminent threat to a fair and impartial orderly administration of justice as it relates to the petition for the temporary injunction becoming a permanent one. The news media already has gotten involved. It's gone nationwide. There have been threats, death threats made to these individuals. There have been comments about whenever your kids go to school, because that was on the video reporting as well. So you have the potential of avoiding substantial injury to the petitioners if the information is disclosed, their protection rights, privacy under Article 1, Section 23 of the Florida Constitution, the rights of the both children who are minors, one of whom enjoys the same name as his father, and as well as the due process rights by both of the petitioners and on behalf of their children. And I think that the court agrees anything, and that every one of these agencies, their entire files are based upon DCM and contained in all of their reports very explicitly. And again, the information that's been leaked already has resulted in death threats to both of these individuals. And again, that they know where their children go to school, etc.
We'll start with Mr. Smith. I'm going to just go down pursuant to the caption. Mr. Smith, in response to the motion for confidentiality in the injunction case.
Your Honor, the state has no position on those matters. We were in the process of answering a public records request when we did discover your order, and I want to correct something I misspoke or misheard anyway. When we were in the process of responding to that public records request, that's when we found your order. But that's the only thing we could get access to back in May.
When you're saying the order on the order to respond to the petition for mandamus, that order, or the injunction signed by Judge Sanders?
It was your petition, it was your order to respond to the writ of mandamus.
Gotcha.
Which when we saw that, then we looked and saw there was some sort of sealing, which we did not. I've never seen
Understood.
Judge Sanders.
Okay, understood. I just wanted to make sure I understood which one you were talking about.
Right. Yeah, there's so many things, it's hard for me to keep straight. I'm referring to your order.
Very good.
And
okay, I'm sorry.
And so, yeah, but we have no position on any of those things. We will follow the court's direction as to wherever it goes.
All right. Just so I'm clear, Mr. Lambert, I'm going to go to Ms. Robinson next, but was there, I did not see return of service on the injunction in the court file on those parties, to the respondents. Can that kindly be filed? You indicated in the motion that everything was served.
I've got the copies of their emails that it was sent to that day.
They were not served?
No, because it happened so quickly. We got them at all different places, but we confirmed, I think, with 3 of them that they received it.
Okay, well, I'm going to need proof of that
Okay.
filed in the record. Ms. Robinson? You're on mute, ma'am.
There we go. We echo the state's position. FDLE has no position. We will follow whatever statutory exemptions apply or whatever this court ultimately decides on the confidentiality. Otherwise, we have absolutely no position.
Thank you. Mr. Waters?
Good morning, Your Honor. I hate to sound like a broken record, but we echo the position of Ms. Robinson and State Attorney's Office. We have no position. We will follow the court's order.
And thank you. Mr. McGlashan?
Sounds like good morning again, Your Honor. Sounds like a broken record. Again, we follow all statutory exemptions and obviously the court's order.
All right, thank you. Ms. Norbert, do you wish to be heard on this?
I would, Your Honor. Thank you. We're here because the two cases in front of you today involve petitions, from what we understand, by two law enforcement officers. These are public servants who were recently the subject of administrative and criminal investigations involving the jailing of a minor child. They now have invoked this court's jurisdiction, seeking some sort of relief against these various public agencies. But the problem is that the grand majority of the court records in these cases are under seal. So we know virtually nothing about the controversies in this case. As you know, the first case, that's 2023 30354, is currently under super seal. The docket itself is not visible to the public. In the second case, we are able to see the docket, but the majority of the substantive records are also under seal. And that includes the FDLE investigative report, which has been referenced today. I think, for the court, Your Honor, this is a type of record that we routinely obtain pursuant to Chapter 119. The bottom line is that we're working a bit in the dark here. What we know is that petitions were filed, and at some point, at least two motions to determine the confidentiality of court records were filed to maintain that secrecy. We believe that the motions have been pending for more than 30 days, so that's why we initially became involved, because pendency of the motions basically operated as a de facto seal on all these records of substance during that time. The issue, since all of this information has been sealed, is that we have not even been able to assess whether the factual and legal basis alleged by the petitioners here in their filed papers are sufficient to justify any sealing under Rule 2.420 of judicial administration. And as it has also been referenced here, we understand from our own attempts to obtain public records from the city that there was a temporary injunction order issued. And that order is preventing public agencies from disclosing public records that would otherwise be subject to disclosure under Chapter 119. But that order is also under seal. Based on the information that's being discussed today and the papers that the state attorney's office filed on Friday, we did learn a little bit more about the ongoing of these cases. It does appear that the petitioners are trying to maintain a seal on records under the state's expungement statute. As the state attorney has alluded to, that statute wouldn't be applicable here because there was no arrest, there were no formal charges brought, no prosecution. There are no criminal history records in this case as defined in the statute. So from our understanding, what seems to be happening here is that the petitioners are trying to say that any kind of criminal investigation ends up with no formal charges being brought, that the entire investigative file can be deemed confidential. And that's not how it works. Certainly when a criminal investigation is pending and is open, those records are exempt from Chapter 119, but once the investigation is closed, they become public records. And certainly private individuals in these situations can't conceal these records from the public. So certainly two cops that have been under investigation, where there's certainly a heightened public interest, can't expect to keep those matters secret either. And Your Honor, any public record that's not independently exempt shouldn't be sealed. There are indications of attempts of oversealing in this case. In fact, just last week, the court issued a letter to petitioner's counsel indicating that what they were trying to seal at that point was it didn't fall under 2.420 and it would not remain exempt unless they filed a motion to determine confidentiality. And again, the entire docket being sealed, the motions themselves, seeking confidentiality being sealed. And Your Honor, and that's despite, Rule 2.420E1 requires that any motion seeking confidentiality should not contain the confidential information in and of itself. The motions themselves are supposed to be open, and any sealing of those motions would get the presumption of openness of court records and proceedings. Rule 2.420 sets forth the proper procedures for sealing court records, and it requires that any motion and hearing on the closure be open and noticed to the public. And of course, we're here today, but quite frankly, we can't speak to the substance of any of these motions because, again, we haven't seen them. The bottom line here is, we're hoping to unseal those motions. We would like to request a later opportunity to respond to those motions and be heard on them before any ultimate ruling is made on whether certain requests should remain under seal. That the determination of what court records should be sealed needs to be done on a document by document, line by line basis. It has to be no broader than necessary, and there can't be any less restrictive means available to meet whatever stated interest the petitioners are alleging. So in other words, if there is a legitimate reason, as prescribed under 2.42, one of the enumerated reasons that sealing would be appropriate, and it can be protected by discrete redactions, that would be a less restrictive alternative than sealing the entire record.
Ms. Norman, thank you. You don't disagree that the statutory exemptions under 119 and 39 certainly still can't be circumvented under, I think there's an exception under 39/2021 that allows by motion that even things, Chapter 39 records can be released from confidentiality on a specific motion, but you're not disagreeing that those statutory protections under 119 and 39 are not, they apply.
Of course there is, yes, it would apply, but again, for the court records to be sealed, it would have to fall under one of the enumerated exemptions in Rule 2.42.
Understood. Brief reply, Mr. Lambert.
Judge, with regard to Rule 2.420, we did outline those reasons as to why we believe it applies across the board to the petitioners. In addition to me today as an officer of the court, I do have copies of the transmissions and threats to these individuals as a result of what's been released already. The fact that, their child's daycare center was divulged. That, again, one of the children shared the father's name. Having a record sealed or expunged is just a minute portion of this. Again, this has begun as a result of a petition for temporary injunction, which was granted, and I think what needs to occur then is the issue whether or not that injunction becomes permanent. But in the interim, whether or not this information remains confidential. There are some cases, Judge. I cited one in the motion, which was the Times Publishing case. There's also the Arnhart case. There's also a case that's integrated records of the Department of Children and Families. It's 873 7nd 506 2nd DCA 2004. In that case, some information had already been divulged And therefore, I think it was Miami Herald was saying that, you know, since it's already out there, go ahead and release the rest of it. And the court said basically, absolutely not. You still have to.
Was that case cited in your papers, or you're just
No, ma'am.
citing it to me now?
I'm sending it to you.
Do you have a hard copy of that decision?
I didn't bring it because judges usually say they don't do, but I looked it up online.
All right, so 873-506 is what you said?
Yes, ma'am. And then there's also the Bernard case, again, which autopsy photos, but at the end of it, the 50CA talked about the unique right to privacy established by the Constitution of the State of Colorado in Article 1, Section 23.
All right, so we've had a lot procedurally to unpack here. So just so I'm clear, we've got to set the injunction for a final hearing.
Yes,
And so that is first on the list. I would like proof of service to all of the respondents because I was concerned about that. So that's where I really kind of want to get that set as in terms of that injunction because it can't. It's designed to be to maintain the status quo until there's a final date. There's been no complaint filed referencing with normally when I get an ex parte injunction, I have a complaint that's filed, but there's been nothing filed.
Right.
But none of the respondents, if they have been served, moved to dissolve it. So it's put it in a position where I'm gonna respond to set it for a final hearing in short order after managing my trial docket, which is a little busy this month. Mr. Hymes, I did not mean to overlook you. Is there anything that you wish to add?
No, Judge, like I mentioned, we've gotten several media requests to, to get these files open, and of course, the clerk under 2.420 has, directions and such rule that, we try to follow the best we can. And, I understand the media's perspective, I understand the petitioner's point of view as well. And all I'm here is, to ensure that we answer any questions that the court may have. And also, just to alert the parties in court that whenever we do get an order, there is specific rule under 2.420, E subsection 3, which outlines exactly what the clerk needs, when an order is entered under the motion for confidentiality.
All right. Anything additionally, Mr. Lambert, after Mr. Hymes?
Thank you.
On the motions to determine the confidentiality of court records, I think I've been pretty straightforward in my position on this. And no one's disagreeing that under Chapter 119, petitioners' names, addresses, or certain personal information as to them are confidential by statute, as is the records of the Department of Children and Families under Chapter 39, which if I didn't allude to the statute specifically, that's Chapter 39. 202, that those records are confidential statutorily. I've considered the motions, the position of the petitioners and the no position of the respondents. Ultimately, I've got to balance where we are, where we've come from, where we've been. So to the extent that, as my ruling on both motions for confidentiality, I'm going to grant them only as to what is statutorily exempted under 119 in Chapter 39, and deny as to the remainder of the motions. So what will be remain, which I'm required to do under the statute, is what I've alluded to as to the petitioner's personal information and the records of the Department of Children and Families in Chapter 39. I'm going to deny it as to the remainder of any other records in both cases. I will also pursuant to the statute, Mr. Hyman, so you're aware, is allude any we're going at this juncture put pseudonyms in as petitioners, and then any reference to the children will be appropriately initialed as we do in any 39 case. Mr. Lambert, if you could prepare a proposed order in that regard, and what's going to happen is we'll have the final hearing on the injunction. The issue becomes the injunction is precluding the release of certain records by these agencies, not making with their records or their records. So to the extent that I deny the confidentiality, they can govern themselves accordingly. But if you could prepare the proposed order in accordance with Rule 2.420, and I would like you to circulate that order to each of the respondents, and then we'll, if the clerk's office has any questions, we'll certainly sort that out.
And Judge, every one of the agencies, all of their records are based upon DCF, which they repeat throughout their reports.
Well, to the extent that, they know what to do in terms of what they need to redact in those documents. So they'll take those necessary protections as it relates to any 39 records. I don't think there'd be any disagreement from that, and I've been very clear that we've got to comply with what's required under the statute in terms of being exempt under 119 and 39, so they can do the necessary redactions that they need to do in those documents.
And the same with the office.
Correct. Thank you, everyone. Have a good rest of your week.
Thank you.
Thank you. Thank you. We're in recess.